Morning. I'll now call to order the February 12th, 2026 general business meeting of the Louisiana State Police Commission. Ms. Erica, would you call roll, please?
Russ Bourgeois,
Present.
Mark O,
Here.
Michael Dubas.
Here.
Stephen Guidry,
Here.
Jonathan Curran.
Yep.
Jim Kowalski.
Here.
Monty Montalago,
Here.
Lenore Feeney. Here. Jason Hanneman,
Here.
Erica Dorsey. Here.
We have a quorum. This time we'll observe a moment of silence and please stand, followed by the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all. Now move to the opportunity to address the commission regarding items on today's agenda. Have any submissions? Without any submissions for public comment, we'll move to the election of officers per State Police Commission Rule 2.1B. I'll accept nominations for the office of the chairman.
Chairman, I'd like to nominate Monty Montalago, chairman. Second.
We have a motion and a second. I won't dispute it. Too much here. I'll accept the nomination. We'll vote on the nomination. All in favor? Aye. Any opposed? We'll do the same for vice chair.
I would nominate Mr. Bourgeois.
Second the nomination.
So moved in second. All in favor?
Aye.
Any opposed? Both motions pass. We have officers for the 2026 season of. With that, we'll move to the meeting minutes from the December 11th, 2025 meeting. Is there a motion to approve? Make a motion. So moved.
Second.
Any discussion? All in favor? Aye. Any opposed? Motion carries. And with that, we'll hear oral arguments on pre-hearing motions filed in the matter of James Jefferson, Department of Public Safety and Corrections, Office of State Police. Docket number 25-276S. Joe Kraft, Mr. Brett Connor, Mr. Jefferson, we had CNO and the Office of State Police.
Good morning, Jill Kraft on behalf of Officer Jefferson, who is here seated to my right. I have some documents that have made copies. I hope it's enough, might not be. They are actually the attachments to our motion for summary disposition. If I can approach. It's the same attachments. If you want to.
Thank you.
Thank you. I killed a number of trees in the process, so I want to make sure I make good use of the poor dead shells. This is a fairly simple and straightforward matter. Again, I don't write the Louisiana State Police Commission rules, but they are in effect and they do bind the obligations of both the body and the appointing authority. Our motion for summary disposition involves two very significant matters. The first, which is Rule 12.19, and that is, as it relates to an investigation of an officer, the state police must conclude the investigation within 60 days of the initiation of the investigation. In your packet, you're going to see a couple of things. The first item is the February 6, 2025 notice to my client that he is on administrative leave pending an investigation. In other words, as of February 6, 2025, the investigation of Mr. Jefferson commenced. It was investigated relative to an allegation by his wife that there was some sort of domestic abuse. You'll also see, by the way, in the packet where charges were refused and he has not been criminally charged. But for the purposes of our discussion on summary disposition on 12.19, the rules are very clear. Once the investigation begins, there's a 60-day period. The next item in the packet is the February 13th letter to my client, and you'll note it says, "Dear Lieutenant Jefferson, you are currently the subject of an administrative investigation, which, as we know, began on February 6th. This letter serves to notify my client of his rights for the purposes and obligations when there's an investigation, specifically to cooperate fully." The next item, which we've labeled as item C, are the findings of that administrative investigation, which you'll see were signed on April 9th, 2025. They were delivered to my client on April 10th. The problem with that is doing the math from February 6th to April 9th, that is 62 days, which violates Rule 12.19. It's frankly that simple. Additionally, one of the things that we have argued is that my client was ordered to serve his alleged suspension time before he ever received a pre-disciplinary notice. Your rules specifically require that my client receive pre-disciplinary notice before he is ever given any kind of discipline. Mr. Jefferson is here, and I'll ask him to testify to you guys as to how it was he received the exhibit, which is labeled as Exhibit C, the April 9th findings of the administrative investigation and what transpired from there, if that's acceptable to you.
Where to tell the truth, the whole truth, and the truth will help you.
Lieutenant Jefferson, by way of background, can you describe the length of time you've been with state police and the current rank you hold?
Lieutenant with Louisiana State Police, currently serving the Gambling Enforcement Corporate Licensing Division of Lincoln State Police, approximately 19 years.
And in February and April of 2025, what position did you hold at state police before the transfer?
I was a lieutenant in the Supply Division,
Yes, sir.
Police Logistics Supply Division.
As I understand it, sir, you were notified on February 6th that there was an investigation.
Speak up, please. I'm
We
sorry.
just need you to get real close to that mic. If you need to adjust it, that.
Yes, ma'am.
Perfect.
Okay.
Thank you.
And I am correct that, to your knowledge, the investigation began on February 6th, which is reflected in the administrative leave pending investigation notice you received.
Yes, ma'am.
Can you tell the commission what happened from there?
From the notification, I then went on administrative leave. I was on admin leave for approximately 62 days. On April 10th, I received a call from Captain Pat Jackson saying that he needed to come to my residence to deliver and have some paperwork signed as it related to the internal affairs investigation. We agreed upon a time approximately 11:30 on April 10th. He arrived at my residence in my unmarked state police assigned
Unit?
unit.
And
Yes.
so we can describe, when you were on administrative leave starting on February 6th pending that investigation, your unit and I think your gun and badge were taken from you, is that right?
Yes, ma'am. Proper procedures when you're placed on administrative leave, all equipment is returned to the department while the investigation takes place.
So on April 10th, tell us what happened.
April 10th, approximately 11:30 that morning, Captain Jackson arrived to my residence, driving by Louisiana State Police assigned Chevrolet Silverado. And Major Nicole Kilgore also arrived in a separate unmarked dark colored Tahoe. We met, exchanged pleasantries, and he advised that he was returning all of my equipment and that he had received instructions to deliver a decision page that ultimately explained the results of the internal affairs investigation and discipline that the superintendent intended to impose. He presented me with that yellow folder. I read through it. I signed the receipt saying that I had received that. He went on to state that it was his knowledge that I was to return back to work immediately. At that point, Major Cole Kilgore stepped in and said, the superintendent, in addition to returning to work immediately, the superintendent had agreed to allow me to serve the 48-hour suspension. That was what was, that was the determination at the conclusion of the investigation. That he would allow me to serve those 48 hours in intervals to not cause financial distress to my family. He said that the ultimate expectation was for me to return to work and provide a outline of the dates that I would like to serve the suspension as per her instructions from the superintendent. I told them that I was not prepared to return to work on April 11th, but I would be prepared to return to work on April 14th, which was that following Monday. And that's in fact what I did. I returned to work on April 15th, and upon coming back to full duty status, I had a conversation with Captain Pat Jackson, and I told him that I had spoken with my wife and we agreed that that serving a suspension would be best the following week, which would be April 21st, the week of April 21st through April 26th. And he said that he would take that information and get it approved, and then he would get back with me to let me know.
Let me ask you a question. When you received the request from your superior officers to give them a timeline for when you were going to serve that suspension, did you consider that to be something you could just disregard?
No, ma'am. State police policy states a lawful order is an order or an assignment that is issued by a superior officer, and a commissioned officer shall conform and follow all lawful orders given by a superior officer. And Major Nicole Kilgore's instructions and her expectations was a clear order to me to return to work and provide that documented outline of the dates that I would serve that suspension. That's what I did. Those were the directions. That's what I followed. That Monday, I informed Captain Jackson of those dates. He said that he will get back with me, and we spoke again about it on that Tuesday, which was April 15th, where he said that it had been approved and that the first initial could be served that week.
Members of the commission, before you, it labeled as Exhibit D is a time and attendance record for Lieutenant Jefferson. It reflects that he served a leave without pay from April 21st to April 25th. And the second page reflects that he also served, I believe, a leave without pay on May 2nd, 2025. Lieutenant Jefferson, you served the suspension of 48 hours before you received the pre-deprivation notice on May 14th, 2025. Is that correct?
Yes, ma'am.
Members of the commission, before you, labeled as Exhibit E is the notice, the pre-deprivation notice dated May 14th, 2025. And sir, at some point in time, you then contacted me, is that right?
Yes, ma'am.
Before you, members of the commission, is my letter dated May 20th, 2025, pointing out to state police that it's a violation of their rules to require somebody to serve a suspension before they've even received a pre-deprivation notice. In response to my letter, the state police, sir, what if anything happened? What happened to your time? You already served the suspension.
Yes, so once we had a conversation and you responded to the mail, that's when the department made a decision to pay me for the 48 hours that I had served and move forward with imposing the same 48-hour suspension in a separate letter that outlined their reasons for making that decision. But ultimately, the initial 48 hours, I was paid back, and then I served the 48 hours a second time. And ironically enough, the instructions that I received the second time was the exact same instructions that I received first time, meaning once the 48 hours was reimbursed and the discipline was installed again, I received directions to provide dates and times that I would prefer to serve the suspension. And that's what I did, same process that I did the first time, the exact same process that I followed the second time.
Members of the commission, before you as Exhibit H are the two, and I'm gonna call them letters of, I don't know, correction-ish, dated June 20th, 2025, and the second one, June 24th, 2025, wherein state police acknowledges that my client should not have been made to serve a suspension before receipt of a pre-disciplinary notice. The last 2 pages, may I approach? This document in your packet, it looks like a 1, but it's supposed to be probably an I. It's entitled Incident Report. Lieutenant Jefferson, did you prepare that document?
Yes, ma'am.
And why did you prepare that document?
Notified me that it was a violation of the State Police Commission rules. I had served the suspension. Properly.
Okay, and in that document, you acknowledge what, sir?
I acknowledge that the conversation took place. I acknowledge the date and the time that Captain Jackson and Major Nicole Kilgore arrived at my residence. I acknowledge the fact that we had the conversation, even specifically asking, once Major Kilgore informed me that the superintendent gave the instructions that I would be able to provide a timeline to serve the leave without pay, I asked her, I said, well, is there an option to serve the suspension at a reduced pay rate? And she directly responded, no, the superintendent wants you to serve all 48 hours of the suspension and leave without pay.
And the last section, the last paragraph of your incident report documents what, sir?
So finally, from the conversation with Captain Jackson and Major Kilgore on April 10th, in addition to the discussion with Ariel Williams advising me of my transfer, it was apparent that everyone knew I was serving a 40-hour leave without pay during the week of April 21st through April 25th. From that conversation with Major Kilgore on April 10th, it appears that Colonel Hodges gave the directions that was communicated to me.
In the last page of your documents that I presented to you, I'm going to show Lieutenant Jefferson. There is an email from Jonas Martin, you dated July 21st, 2025. Is that correct?
Yes, ma'am.
And that's an email that you received?
Yes, ma'am.
Members of the commission, I'll point out to you that once again, we have the same problem. A client received this email dated July 21st, 2025. In the packet, you'll see labeled as Exhibit G is actual imposition of the discipline on August 6th, 2025, which was, oh, they're doing the math roughly, 2 weeks before he was actually served with the formal notice of discipline. Rule 12.8 requires that except as provided in Rule 12.5, which does not apply here, a permanent employee who is disciplined shall be given prior written notice of the action which states the action which is to be taken and the effective date and time thereof. Lieutenant Jefferson, did you respond to this request by your supervisor, it's Captain Martin?
Yes, Captain Jones.
To again give dates you were going to serve the suspension which had not yet been imposed and was not imposed until August 6th?
Yes, ma'am.
I have no further questions.
I just got a couple. Lieutenant, where in your report does it say that you were ordered to take your suspension?
So again, according to the United States Police policy, it defines a lawful order as any order or assignment that a superior officer gives a commissioned officer. It goes on to say that a commissioned officer shall obey such orders. And so that the idea of the order came as outlined in the policy where it says assignment. My assignment was to return to duty immediately and provide an outline of the days that I would serve the suspension. And so that was the order the assignment that was given, I was compelled by policy, bound by policy to follow that order.
So according to your report, do you need a copy of
Oh, I
it?
can see that. That's fine.
You said, going along your lines of being ordered, you said that you were, requested that I return to full duty the following day, April 11th. But you said you were unprepared and that you reported to work April 14th. So is that an order to return to work April 11th?
The order was to return to work immediately, which was April 14th. And to provide an outline of the dates that I would serve the suspension.
And on the second page of your report, you use the words informed and requested.
Yes, ma'am.
Why, if you were ordered, why you didn't use the word ordered? Ordered.
An order is defined as a order or an assignment. In this case, the assignment was to work immediately. 14. Part of that assignment was to provide an outline of the dates to serve the suspension.
Okay, that's it, Commission.
I have no further questions. Come on. So members of the commission, if I may, the problem with this is, however altruistic you want to believe the motivations of state police are, and they may have been good motives, let's try to not hurt this guy too much. The problem is the rules are the rules, and the rules are there because at the end of the day, my client's entitlement is a constitutional right to his job. It cannot be taken away without adherence, strict adherence to due process. It's that simple. This commission defined by rules as allowed by statute and constitution what it is they believe due process was before the imposition of discipline on my client. I will note that even as of July 21st, 2025, when my client received the email from Captain Martin, what he says is, Captain Martin, I've been contacted by legal regarding your pending disciplinary suspension. They have requested dates for you to serve your 48-hour suspension. And then it says LSP 211-3 states a disciplinary suspension without pay shall not begin on or include the employee's regular days off, any paid holiday or any leave taken. Please provide me with a range of dates to provide back to legal to prepare the final letter. Here's the problem. You see, if due process means anything, that means somebody has to consider my client's response to the pre-deprivation notice. It also means he can't be required to serve his suspension before he gets the pre-deprivation notice. And it also means that he can't be required to give them dates for him to serve a suspension that has not yet been imposed, and it was in fact not imposed until August 6, 2025. I submit to you, if the motivation from state police was, let's work with this guy, they certainly should have issued their August 6 letter. And if they wanted to thereafter say to Lieutenant Jefferson, we can work with the dates and help you if we need to modify the dates, that's a whole different question. But your rule is unequivocal and it is mandatory, 12.8. Except as provided in Rule 12.5, a permanent employee who is disciplined shall be given prior written notice of the action, which frankly didn't happen. He did not get his disciplinary letter until August 6th, 2025. For those reasons, chiefly being the issue that he was required to serve his suspension before it was even a thing, before he was issued a pre-disciplinary notice, which didn't occur till May. I acknowledge that state police, after I sent them a letter on May 20th, said, you guys can't do this. It's in violation of the rules. Then they came back and said, well, let's try to fix it twice, April 20th and April 2024, 2025. And as we proceed forward, it still wasn't correct because then they're reaching out to him at the request of legal, according to the email on July 21st, 2025, saying, give us the dates you're going to serve the suspension, which has not yet been imposed on you and wasn't until August 6th. For those reasons, I submit this case is ripe for summary disposition. And I submit the documents that I gave you earlier and request that they be introduced into evidence. Thank you.
Good morning. First, we would like to address the timeliness of the investigation. The appellant was arrested on February 5th by BRPD for domestic abuse with child endangerment.
Excuse me.
Introduce
yourself for the,
so
that it's all on there.
Juliet Ciano on behalf of State Police. Y'all can hear me good?
Can you hear?
Okay. The appellant was arrested on February 5th, 2025 by PRPD for domestic abuse battery. Then on February 6th, the appellant was placed on administrative leave pending investigation in accordance with Rule 12.4. After more facts were gathered, on February 13th, the appellant was advised that he was the subject of an administrative investigation pursuant to Rule 1213. On April 9th, the investigation was concluded and the colonel determined that he intended to discipline the appellant with a 48-hour suspension complying with Rule 12.19E. On April 10th, the appellant received written notice that the investigation was complete and his proposed discipline was a 48-hour suspension in accordance with Rule 1219F. From initiation of the investigation on April 13th, 2025 to the completion of the investigation on April 9th, 2025, that is 55 days, well within the 60-day requirement under Rule 1219A. The appellant's assertion that the administrative investigation began on February 6th is just plainly a mistake. The investigation was timely and properly initiated. Administrative leave pending investigation is an employment action that is temporary and precautionary. It allows the department the time to gather the facts and evaluate these facts to determine if an administrative investigation is warranted. The appellant was placed on administrative leave pending an investigation on April 6th. None of his leave time was affected. Facts were gathered, and a week later, on February 13th, the appellant was informed that he was the subject of an administrative investigation. For reference, this is LSP's Exhibit 2 that it was attached to our memorandum in opposition. LSP complied with Rule 1213 and provided the appellant notice of the administrative investigation that included the date of the alleged offense and the substance of the factual allegations. The investigation began on April 13th and ended on April 9th. Again, 55 days, well within the 60 days required to complete the investigation.
I'm sorry, you said April 30, you meant February.
Yes. The investigation began on February 13th and ended on April 9th. Well within, it's 55 days, so it's well within our 60-day time frame.
Do you contend commencement of an investigation?
When they're able to establish a date that the alleged allegations occurred and some factual basis to sustain, to show some substance of an investigation.
And what do you contend was the date on which they developed facts that suggested that possible discipline might be imposed? Certainly, the arrest of a trooper would alert the appointing authority that if those facts that predicated the arrest were true, there would be disciplinary action. Wouldn't you agree with that?
To answer your first question, the facts that were gathered to provide substance that disciplinary action could be warranted, that determination was made on February 13th. The date that a letter was drafted that he was a subject of an investigation.
How did those facts differ from the facts upon which the authority relied to place him on admin leave? What additional facts did they learn between placing him on admin leave and issuing February 13th letter?
So on April 5th, on April 6th, all we had was he was arrested by BRPD. They took
February.
February 6th, I'm sorry. On February 6th, all we had was he was arrested by BRPD. Within that week timeframe, they were able to obtain the police report. They gave additional facts that substantiated that there was conduct that occurred that could warrant discipline. So we had internal affairs had to wait until a police report was obtained.
When was that obtained?
Within that week timeframe, between February 6th and February 13th from BRPD.
That would matter, and it was obtained in that time frame because sometime in that frame would put it inside and some might put it outside of the 60.
What do you mean?
Well, I think it's 62 or 63 days. So if it was obtained the next day, you still got 61 or 62 days. before completed.
So we have, according to rule 12, 1 second. According to rule 12.13, Louisiana State Police trooper being investigated shall be informed within 14 days of the start of the investigation that the trooper's under investigation.
Yes, but that means,
And
the investigation starts and you have 14 days to let them know. What was the date that the investigation was launched?
February 13th. After we were able to obtain a copy of the police report from BRPD.
Okay, so what date was the police report obtained? I think it was Mr. Dubos's question.
Don't have that date. His arrest was on the weekend, so it gave a couple days for them to obtain it.
You know what date an investigating official was assigned?
I'm sorry.
When was an investigating officer assigned in this case?
February 13th.
How was the state police notified of the arrest?
Don't know, we don't remember how it was initially, I mean, it was on the news, it was by the media, it was covered by the media.
Right, but did the appellant notify his supervisor? Did Baton Rouge Police reach out to somebody with the state police?
With the commission's permission, we'd like to call Colonel Hodges to answer those questions as far as how the department was notified.
Swear to tell the truth, the whole truth, and nothing but the truth. So help you God.
Good morning.
Can you advise the commission when the department was notified of Lieutenant Jefferson's arrest?
For the record, Colonel Robert Hodges, Superintendent, Louisiana State Police. Question, please.
Can you inform the commission of the date the department was notified of Lieutenant
That's
Jefferson?
why I have my phone. It was during Super Bowl week. We were on assignment in New Orleans for that week, as everyone knows how busy and consuming that was. So as I go back to look at my calendar, please bear with me. It was overnight that we were notified by the Baton Rouge City Police. We got contacted by the Lieutenant City. I don't remember the name, but he actually contacted Lieutenant Colonel Cordell Williams, who was at the time Jefferson's deputy superintendent, who notified me. We were all, if y'all recall, doing the Bourbon Street remembrance of honoring January 1st terrorist attack with the street closure. So it was about 2:30 in the morning when we got the notification that it happened earlier that night. And I'm going to give you the answer to your question. Just bear with me one moment. So I can. Sorry, I don't have the date in front of me of the document, but it was a Wednesday night, Thursday morning. And the exact date technically was Thursday, February 6th. Thursday, February 6th is when we were notified verbally. Didn't have all the details, had some details, knew Jefferson was arrested and that there was a felony charge involved and that he had to be physically arrested because of the domestic and the juvenile, related to two charges.
Colonel Hodges, do you know what date it was that you assigned an investigative officer to the case?
So let me look at the calendar again. So the date we assigned someone to it was the 13th of February. And the reason for that is twofold. Is because we were waiting for the city police, local police in this case, it was Baton Rouge City Police, to give us the information. Just a booking sheet from the jail is usually not sufficient. Very complex matter when it involves domestic cases. We didn't want to rush the district attorney. We didn't want to rush the sheriff's office at the lockup with any of the details. We wanted to be fair and impartial, because obviously, so we got the information. And once we had that, then we could in turn submit the official letter saying an investigation has begun. Once we had something of substance, we always would like to give the benefit of the doubt to anyone as such, that it's impartial and fair. We get those.
That's all the questions I have, Colonel.
Colonel Hodges, you're not telling this commission that you were unaware of the arrest of Lieutenant Jefferson until February 13th, is that right?
No, ma'am.
You are aware that upon my client's arrest, he immediately notified Captain Jackson. The arrest was approximately 10:30 p.m. He notified Captain Jackson. He indicates sometime right after midnight on February 6th. Does that sound right?
I was notified again by Lieutenant Colonel Cordell Williams, Deputy Superintendent of Support. It was sometime in the early morning hours when we were on assignment on Bourbon Street. So I don't have the exact time, but it was after midnight, and that's how I was notified.
On February 6th.
Thursday, February 6th.
And was it your understanding that Captain Jackson had notified Lieutenant Colonel Cordell Williams as a result of Lieutenant Jefferson notifying his superior officer of the arrest?
I don't know exactly how it came to Colonel Williams at that moment, but I was notified, obviously very surprised and disappointed all at the same time, because I had seen Lieutenant Jefferson the Monday night at the Superdome for the opening of the Super Bowl festivities with his two children.
And so we're clear, as if my calendar is correct, February 5th, 2025 would have been a Wednesday, and the notification, as far as you were concerned, of my client being arrested was the early morning hours of Thursday, February 6th. Yes,
That's correct.
the Super Bowl was Sunday, the following Sunday. You issued a press release, did you not, on February 6th, 2025? Do you recall that?
Based on the information from
You recall that press release being that you were aware that Lieutenant Jefferson had been arrested for domestic abuse battery and was facing charges as a result of an arrest by the Baton Rouge City Police Department? So this information that you're telling the commission, we didn't really know. We had no idea. In your press release, you fully acknowledged the charge my client was arrested for, the severity of the charge. You even made a statement, I think, something about we take these matters very seriously. So are you really telling this commission that you didn't commence the investigation until February 13th?
That's correct, and the reason for that, I want to clarify, is when an arrest is made by an outside agency, we don't have the information or details on the case. However, to protect our agency, certainly someone has to be placed on administrative leave, but as far as an assigned internal affairs investigator, that we have to gather the information, so you're at the mercy of the arresting agency, in this case, the Baton Rouge City Police. It is not common. Rather, it's very common in cases that it takes days to get the information, us to look at it and assign an investigator. You don't quickly start investigating something while another agency is still completing their investigation of that incident, which requires writing a report, having a supervisor approve it, and then get it to us. So we had to patiently wait for the information from the local police. And once we got that information, then we were able to issue the letter on the 13th advising an administrative investigation would commence. So there's two parts here which needs to be made very clear. The criminal investigation, which obviously was done by the local police, and then we in turn moved an administrative investigation on the 13th, which is customary in a lot of cases, unfortunately, where we've had some of our agency troopers over the years involved being arrested publicly, and then an internal investigation following once we get the information from that arresting agency, whether it's a sheriff's office, police department, or federal.
Approach the witness.
Yes.
I'm going to show you a document which we've introduced, sir, and correct me if I'm wrong. This is a letter dated February 6, 2025. You actually signed this letter, am I right, sir?
Well, it's my signature, but I'd have to look at the letter so we
Yes,
can
sir.
qualify what it is. It's administrative investigation. This is saying that in this case, Lieutenant Jefferson was placed on administrative leave.
And so my
due
question
to the
was,
arrest.
did you sign this letter?
I did.
And it doesn't say due to the arrest. What it says is pending investigation. So do you mind telling this commission what investigation was pending against my client as of February 6, 2025, when you signed this letter? What investigation?
There was no investigation. The investigation was pending the receipt of the details from the local police.
Well,
You
why?
can't start your investigation without the information from the arresting agency.
So then why would you sign a letter that says my client is being placed on administrative leave pending an investigation on February 6th when you're telling this commission there was no investigation? You understand, sir?
No, he was physically arrested, ma'am, for
Uh-huh.
felony charge, which means at that time, per the policy, we have to obviously put him on administrative leave because he can't perform his duties. One, he's physically arrested in a jail. Secondly, until we get the criminal arrest report, and then we can in turn start an investigation with the details. This is two parts to this, and I need it to be clear. He's placed on administrative leave, which is immediately done once we're notified of these serious allegations. And then you have to patiently wait for the arrest report, and that's common. I would not want any agency who's investigating one of our troopers to quickly rush and complete the case. We need them to follow their normal protocols, policies and procedures, get us that information, and then we can start. So this letter that was signed by me is more to advise, yes, there is an investigation. You're on administrative leave, but we don't move forward until we had that document from the arresting agency.
So when you use the word investigation in that document, I believe it's 4, maybe 5 times. What exactly were you talking about? Because see, under Rule 12.5, you can suspend my client pending an investigation, but that's an investigation by y'all. So when you're saying investigation in your letter, you signed February 6th, exactly what investigation were you talking about?
Which referenced the arrest.
Okay, so the investigation of my client started on February 6th.
It did not start on February 6th because we didn't have the information. He was placed on administrative leave upon notification. I understand maybe the complexity of it and the technicality, but the reality is they have to be placed on administrative leave. No one in our agency or anyone on this commission or in the public would want someone to retain all of their equipment and gear while they're one in jail and two under criminal investigation prior to administrative investigation. So we can't start both things jointly. We have to wait for the criminal part, which we waited for the information, but they do get the letter, so.
So this letter, the second document, which is before the commission, is dated February 13th, and I understand you didn't sign that. But if you wouldn't mind, can you read the first sentence of that letter for the commission?
Incredibly small, so I apologize. You're currently the subject of an administrative investigation, the number assigned to this case.
Okay, so what I wanted to point out, and I circled it to make sure I understood correctly. In this letter that was issued to my client on February 13th, what it says is you are currently the subject of an administrative investigation. So as of February 13th, if my client was currently the subject of an investigation, are you really telling this commission the investigation didn't start until February 13th? Because in this letter, you're welcome to look at it. It doesn't say anything about the investigation commences today. In fact, what your department said is the investigation had already started. Do I have that right or wrong?
The prior letter said that an administrative investigation would begin with administrative leave. And that was the part of it. The investigation did not begin until the 13th.
Then why doesn't it say that in that letter, sir? Because what it says is you are currently the subject of an administrative investigation. How come it doesn't say the investigation commences today?
Because at that point, we had the arrest report from the city police, the criminal arrest report.
Switching gears, sir, if you don't mind. Were you the one who gave the order to Major Kilgore to have my client provide dates that he would serve his suspension before he was issued a pre-disciplinary notice?
No, ma'am.
So do you know where?
I want to clarify a couple of things, in our process for internal affairs. We have a decision letter, which comes after the disciplinary review committee. And that's a letter saying it's letting the trooper or the trooper know that there's pending discipline, and here are the violations that were sustained, here's the number of hours. That's a decision letter, and then there's a final letter. I realize council is using different terms outside of how we refer to it as, but it's a decision letter and then a final letter. So the employee or the trooper in this case clearly knows that there's pending discipline. And so they know in advance that the discipline is coming. And then to your question about the directive of trying to allow them to find days that will work. So we can work with our troopers to coach, mentor, and train them and help this corrective action, get them back to where they need to be in good standing in the agency. I directed the command to get with Lieutenant Jefferson to find out what dates would work best, because he has a job to do, that he was on administrative leave and gone for a considerable amount of time. And we need him to return and get back to work and do the job and responsibility that he's assigned to do.
Well, with all due respect, sir, if that's accurate, then what is the purpose of your letter to my client dated, make sure I get the date right? It's in the packet as Exhibit E. This is a letter you issued to Lieutenant Jefferson, I'm sure it's signed by you. Yes, it is. Dated May 14th. It says intended 48-hour suspension. So what is the purpose of that letter if it's not to give my client notice of possible discipline and constitutional opportunity to respond before the discipline is imposed?
Please bear with me, it's several pages. So. So as already mentioned by both LSP and by council inside, the two letters, we had a two-part process. Again, one was the decision letter and one was the final letter, watermill letter or policy. And there's one is the intent, and the other is the final letter. They look very similar. And I realize I'm not an attorney, but there is a difference, and Lieutenant James Jefferson knows that because he spent several years in internal affairs as a supervisor. But the first letter is intended suspension.
That's the May 15th letter, is that correct?
Well, I don't believe all the letters are here that you provided.
So the one that you're talking about.
But let's be clear to the
Yes, sir.
commission and everyone present.
May 14th, my apologies,
I don't-
Exhibit E.
We don't have both letters,
Yes, we do, actually,
the
the,
decision letter or what we refer to as the final letter. One is intended or a decision letter, and one's, of course, the final letter or the discipline letter.
the discipline letter, sir, if you'll flip forward, is actually in that packet. And I believe I can show it to you. It's dated August 6th.
So why would the decision letter come before the final letter?
Here's your final decision letter imposing the 48-hour suspension on August 6th, 2025. Can you explain to the commission why you requested my client's superior officers to obtain from him dates he would serve a 48-hour suspension that you did not even impose until August 6th, 2025?
So the documents that are in front of me, if we're looking at the same one, Exhibit 6,
G.
I'm sorry, Exhibit G. This being the final letter, after we had the
With all due respect, sir, you asked.
Oh, just give me a moment.
Sure.
Please be patient. You've had much time to review all the documents and take special little pieces out I'd like to go through it, work with you.
Certainly.
I think that's only fair. So initially, when the discipline was given to Lieutenant Jefferson, his supervisor did not wait for the final letter and used, as already stated, use a decision letter. And that's why we reimbursed Lieutenant Jefferson his 48 hours. And then legal completed the new letters, which is what council's referring to, where we gave another decision letter, another final letter, final letter because he hadn't received it. So everything had to be redone. We acknowledge the oversight in the process that Lieutenant Jefferson knew it was pending discipline. However, he served the discipline prior to receiving the final letter. So as we stated, we sent another letter, which are these two here, to stay within compliance with the regulation, acknowledging our oversight. And that's why you had the letters delayed beyond the other dates.
But you also instructed his superior officer on July 21st, 2025, before you issued the final discipline letter on August 6th, to reach out to Lieutenant Jefferson and have him tell the department what days he was going to serve the 48-hour suspension, which had not yet been imposed until August 6th. Why did that happen?
Both, I don't know if I'd use the word imposed. The decision was made by the Discipline Review Committee, which I'm a part of as superintendent with the lieutenant colonels, but we make the decision on discipline. We give a decision letter and then we give a final letter. And there's some time in between both of those. But on you're asking on the second time, is that what you're referring to?
No, sir.
You're asking about why did we ask about the days pending the final letter is when those days, when we gave him the opportunity to choose the days to best help the agency and help Lieutenant Jefferson.
So are you saying that the decision to impose the 48-hour suspension on my client was made on April 9th, 2025, when he received that first list of findings? It's in your packet. I can show it.
You have to flip to.
Yes, sir. It's Exhibit C, findings of administrative investigation, which looks like it was signed by you on April 9th. Are you telling me that that was the date that the final decision to impose 48-hour suspension on Lieutenant Jefferson was made?
I'd have, bear with me while I check the calendar.
Yes, sir.
On April the 9th, which this letter is dated.
The date's down by your signature, sir.
April the 9th, we had a discipline review committee in the morning. Letter was signed that afternoon. The letter was a decision letter.
So-
Meaning it's to notify the trooper of the pending discipline, but it's not the final letter.
Okay, so then you acknowledge that you then later sent him a letter on May 15th saying we are considering imposing discipline on you, right? A 48-hour suspension, and you gave him an opportunity, which he's required to receive under the Constitution, to respond.
Certainly.
Okay, so then, again, my question is, why are you having him serve a suspension as of April 9th, 2025, when you know constitutionally he has a right to submit evidence to say, after he gets a Loudermill notice, which was May 15th, to say, this is why I think I shouldn't get disciplined. In other words, why was your mind already made up before giving him an opportunity to respond that he's entitled to?
So we had a signature from Lieutenant Jefferson saying that he received the decision letter. And the final letter, which is issued to him, does provide an opportunity for him to appeal the decision. I think that's why we have an appeal scheduled for hearing commission next month. You're talking about the letters and specifically he served the suspension too early before we had the final letter. We reimbursed him and made the correction. Then we gave the other letters. Then he to serve 48 hours within the guidelines of the commission rules after receiving the letters. And even if you serve the suspension in our agency, you still have the right, to your point, to appeal. And that's the process that is taking place next month.
Okay, but with
And
all,
that's why you've been retained as counsel. The process of saying, I disagree with the suspension or the decision of the discipline review committee, and as superintendent, my final decision to issue discipline, in this case, 48 hours, the employee still serves it. And that's why many members here have seen before, people come here and have their opportunity to plead their case and explain why they don't think they were deserving of that suspension. I think you're asking, or rather making a statement that, well, you didn't wait for him to have it. We received all the information. That's why we're here today.
what do you mean you received all the information?
We received information from your office saying that he wishes to appeal the suspension.
No, sir, I'm talking about when you sent him the Loudermill notice, the constitutionally required notice. That I believe was May 15th. By May 15th, my client had already served the 48-hour suspension because you asked his commanding officers to get dates from him to serve it, correct?
I
Yes.
asked them to get dates prior to him receiving the final letter.
But the final letter, sir, isn't the one that until August 6th that you issued where it says, I've considered your response, Lieutenant Jefferson, to my May 15th letter. I've looked at what you provided, and on August 6th, you said, after I've looked at everything you provided, I decided to impose a 48-hour suspension. My
Well-
question to you is, why then are you having people reach out to him on July 21st and say, hey, again, give us dates you're going to serve your suspension before you've actually suspended him, which didn't happen till August 6th?
So I'll just say that we already stated and answered that we recognize that he served the suspension prior to getting the final letter. Therefore, we made the correction. We sent a new letter, which we got a signature. I took into account the letter from yourself and your client, Lieutenant Jefferson. I read his recommendation, which is sometimes considered where the superintendent has the opportunity to change his decision prior to the final letter. I took into account what he said. We kept with our original decision of the 48 hours. And therefore, 48 hours suspension held. And he served the 48 hours. I think you're just back and forth with these dates. We've already acknowledged the oversight. We made the necessary correction. I took into account the information that Lieutenant Jefferson made. Yes, that the charges were dismissed from the district attorney's office. However, there were multiple policy violations, which I believe match these 48-hour suspension. And as stated by Lieutenant Jefferson, everyone in our agency is held to accountability, and none more than those who have a number of years with our agency, almost 19 years, as well as their position of leadership. And in this case, someone like Lieutenant Jefferson, who previously served in internal affairs, which is a unit of integrity and utmost confidence. Additionally, his experience with matters involving engaging the public and making good decisions.
I just want to make sure I'm clear. When you say the final disciplinary letter, which I believe is in the packet, the one that you issued on August 6th, telling Lieutenant Jefferson for the first time that you have made a final decision that you are going to suspend him for 48 hours. Is that right?
Yeah, bear with me, these multiple documents keep being placed in front of me with incredibly small print in a strategic order. Yes, this is my signature on the August sixth letter for the 48-hour suspension for Lieutenant Jeffs.
That's all the questions I have. Thank you, sir.
That was a question real quick, and I should have asked it earlier, asked the state. I'm asking this in the abstract, not necessarily tied to these facts. In the abstract, what do you contend constitutes the investigation?
Well, in this particular circumstance, they clearly indicated they began the investigation on February 6th because my client was placed on administrative leave pending investigation. When you look at your rules, they can place him on administrative leave pending an investigation. But when I asked the witness, what investigation are we talking about? It's the arrest.
Again, I understand your argument as to this case, but just in the abstract, what actions by an appointing authority do you contend constitutes the commencement of an investigation?
Well, in this particular case, they indicated that they knew my client had notified him he had been arrested on February 6th in the early morning hours. Number one. Number two, they indicated we were waiting to get the police report. We were getting the police report from the Baton Rouge City Police Department. How is that not the beginning of an investigation? Because that's what the point of it is. You know, he's been arrested. You place him on administrative leave pending investigation. It wasn't just you're on administrative leave and there's a provision they could have done that, saying in the, I can't remember the exact language, but it's in the in my discretion of the department, I've decided to place you on administrative leave. They have the ability to do that. But they did it administrative leave pending investigation. And on February 13th, it wasn't a notification of the commencement of the investigation. What they said on February 13th is you are currently under investigation. So, I mean, I think the investigation began when he was arrested and they're trying to get the police report and all that kind of stuff. I mean, I don't know how we could conclude otherwise.
I just want to give you a chance to answer this.
Yes, sir. Yes, sir. Thank you.
I just have one follow-up for the Colonel. Ms. Kraft has been provided a copy of this. Can I approach these?
Actually, I don't think I have.
I just did provide you.
Oh, just now?
Yeah.
Okay. And it was created on February 12th?
Colonel, can you identify what this report is?
This is an internal affairs, formal case report investigation.
And is this created by the agency when an internal affairs investigation takes place?
Yes, when we officially pull a number through our Mark 43 system, our records management system.
And can you read what is under initial complaint on the first page? It's not correct. The first couple.
On Wednesday, February 5th, the Baton Rouge City Police Department responded to the residence of Lieutenant James Jefferson in reference to a domestic altercation between him and his wife, Heather Jefferson. Following the investigation, Lieutenant Jefferson was arrested for domestic abuse, battery, and child endangerment, and subsequently booked in the East Baton Rouge Parish Jail. As instructed by the Chief of Staff, Lieutenant Colonel Frank Bason, Internal Affairs initiated the administrative investigation on Thursday, February 13th, 2025.
And is this documentation in the normal scope and practice of the agency to document internal affairs investigations?
That's correct.
That's all I have.
Can I ask a follow-up? So the document you have in front of you, maybe you can help me understand the confusion I had. Because if, according to you, the investigation began on February 13th, 2025, that's your testimony, right?
That's correct.
And explain to me why the creation date of the particular internal affairs is actually the day before.
Because they pulled the number when they enter in the case.
So did the investigation then begin on the 5th, the 6th, the 12th, or the 13th?
Well, as stated in the initial complaint and or the interviews, which is the summary, as I just stated, the administrative investigation began on Thursday, February the 13th, 2025.
So you're creating a number for an administrative investigation at least a day before you actually make the assignment? Does that make sense?
So when you enter the number in the system,
Uh-huh.
I realize it's the day before,
Yes,
but
sir.
as stated in his comment, they didn't start the investigation until that day.
So in answer to my question, are you telling me that you actually assign an internal affairs number to an investigation that has not yet been assigned according to the narrative body, even if it's a day before? You just, somebody in internal
No,
affairs?
I will just tell you that the way the CAD and RMS system, which is computer automated dispatch and then the records management system, we pull a number when we know a case is forthcoming. In this case, they pulled it the day before, but per the investigating trooper, he didn't start the investigation till the 13th. So if you want to say it's the 12th and not the 13th, to say that the number says this date, but he didn't, in his narrative, he said he didn't start till the 13th.
When was this narrative created?
So accordingly, it's when they start writing the report after they gather facts. So I realize what you're trying to do. You're asking when did, in the course of an investigation, in this case, whether or not the final details in the are probably significantly different. The report was e-signed on March 23rd. And if you look at that, that's the trooper signature, and then the supervisor signed off on it for approval on the same date, sometime after. And so about 30 minutes after, reviewed it. As I'm sure in most cases, especially these type of cases that are very sensitive, the supervisor is probably involved with it directly, especially the first line supervisor, which is the case here.
As I understand your system, you can actually go back and alter dates in any document and change them until it's locked.
I object, Your Honor.
Correct?
I object, Commission. I mean, there's no factual basis for that.
He can answer the question.
Right? You can go back and
You
change.
cannot change the number at the top of when the case was pulled. That's incorrect.
Okay. So if we wanted to be sure when a number was pulled as opposed to when the investigation began, which could be two different things, right? We would have to get the electronic data relating to this document that was just produced to me by Counsel for State Police. In other words, we'd need to go back and forensically determine when it was somebody first logged into that system, right?
Well, this document is the document we stand by. You're questioning whether or not someone changed the date that was pulled out. I think the document speaks for itself. The number was pulled on the 12th, the investigation started on the 13th. And you're trying to question every document that we produce that needs to be forensically analyzed. I think that's very unfair to law enforcement. I think it's unfair to the commission. It's even unfair to Lieutenant Jefferson, because all reports you're implying or can be manipulated. That's not the case with our system that we use. It's been upheld in many courts, and we're very confident that the document we have here clearly states when the troopers began their investigation, as noted in the narrative, and when they received the report from the city police.
And back to your February 6th letter, why did you use the language administrative leave pending investigation on February 6th if he wasn't under investigation then?
I object. He's answered that question already. It's been asked and answered multiple.
Answer based on these new facts.
Why would you say that, sir, if it wasn't true on February 6th to Lieutenant Jefferson, to be fair to him?
Because he's being placed on administrative leave because he was criminally arrested.
But pending investigation is the problem.
And waiting for the criminal investigation to finish from the city police so we can begin our administrative investigation. So when someone is arrested in our agency, by an outside agency, do we just let them continue to work as a state trooper while the other agency completes their investigation? Or do we place them on administrative leave in the best interest of the public safety? And that's what we did. And that's what that letter says. And I think you're trying to bring a word to stretch to something more than it was. Yes, an administrative investigation is going to begin, but it doesn't begin till we have the information from the arresting agent.
So I'm clear, you
He's
stand
placed on administrative leave
pending
with that
investigation,
letter.
pending investigation, February 6th.
Our investigation didn't begin till February the 13th.
You stand by the documents you've signed, sir, right?
Do.
I have no further questions.
I'd like to offer file and introduce this incident report.
Does it have a letter? I mean, you have letters attributed to your other exhibits, don't you?
Yes, I'll label it. I'll label it as Exhibit 11 to follow in line with.
Previous exhibits.
Yes.
Oh, yeah.
We have no further. Thank you.
One clarification, Colonel, in the February 13th letter, are there any facts of the investigation in this letter other than you were arrested by Baton Rouge Police Department for domestic abuse matters? Any facts of the investigation within this letter?
No, just, there is nothing further than the arrest from city police. I'd just like to add that it's in the interest of public trust that we immediately acknowledge these arrests from our agency to the public and not wait. And that's why we do a news release or a media release out, although not a proud day for our agency, something that's required and we've been consistent with over the last 2+ years in my role. And although it's not, I think the word I'm looking for is not a proud day for the agency, but it's something we have to do to continue to keep the public's trust. And that's why we send out those releases in advance, whether it's our arrest as our own agency or an outside agency arrest. Thank you.
And I would just like to follow up with some dates, Mr. DuBose, that you were asking about. On February 11th, Captain Salim Elmi requested the report from BRPD, and
I would like to lodge an objection. I don't have any document or any witness who's testifying to that. If somebody can tell us that under oath, that would be helpful. But like me making arguments, it's not evidence, so I would object to that.
Objection sustained.
as a follow-up to the Ms. Kraft's argument about administrative leave pending investigation, the rule plainly states appointed authority does not possess sufficient facts to support a disciplinary action. So the employee can be placed on administrative leave pending an investigation. If you want to get into semantics about the word pending, you're waiting action, you're waiting for something to occur. This putting Lieutenant Jefferson on administrative leave pending investigation was just saying, hey, an allegation's being made. We need you to take a sideline, right? Sit on the sideline right now. Let us get the facts. Let us determine if we need to proceed forward with an administrative investigation, which on February 12th, the determination was made to issue a internal affairs number, and the investigation began on February 13th. If she wants to say the investigation technically began on February 12th, so it was 56 days, well within the 60-day requirement to conduct an investigation. Secondly, I would like to move on to the premature suspension of Lieutenant Jefferson. LSP acknowledges that Lieutenant Jefferson was prematurely allowed to serve his suspension. However, when the procedural error was brought to the colonel's attention, he rectified it by reinstating his time and allowed the process to take place. Captain Jackson had the hard task of informing a colleague, a subordinate, and a friend of the suspension. A difficult situation turned easier for Captain Jackson when Lieutenant Jefferson requested to serve 40 of his 48-hour suspension while his children were on break from school for spring break. I would like to bring y'all's attention to Exhibit 5 that was attached to our opposition, where Lieutenant Jefferson writes, he doesn't write he was ordered, he writes in his initial report, and this, it's important to note that this document was created without any order or suggestion from any of his supervisors. He states, I informed Captain Jackson, I spoke with my wife and we agreed that I would serve 40 hours of LWOP from April 21st through 25th, 2025, due to my kids being off for spring break. Additionally, as you can see with Exhibit 8, on June 20th, Lieutenant Jefferson was notified that his time would be reinstated because his suspension was premature. The appellant's final discipline was imposed on August 8th, where his suspension was to be served in compliance with Rule 12.7 and 12.8. Commissioners, this was a procedural error by the department, and it was cured. His time was reinstated and his final discipline was issued. This is not grounds to nullify his final discipline. Additionally, the appellant misstates Rule 12.20. This rule does not state anything about discipline being defective, null, or void. The rule plainly states that any discipline action taken against the Louisiana State Trooper in violation of these rules may be reduced. The word is may be reduced, modified, or reversed by the commission. The investigation was timely, 55, 56 days, however you want to pick which date. His notice was proper. The appellant's premature LWOP was rescinded. The department recognized the premature error. Due process was ultimately provided, and final discipline was imposed only after there was full compliance by the department. At most, what occurred was a correctable procedural error, which was appropriately rectified by the colonel. This is not grounds for summary disposition, and the appellant's request should be denied. It is important to note that because of this procedural error, safeguards have now been put in place to prevent this from ever happening again. The appellant has not met his burden of proof that is required by Rule 13.5 to have his appeal summarily disposed, and therefore we request that it be denied. And
I do, this Kraft notes the importance of the Loudermill letter. You acknowledge and agree that that is the touchstone of the due process protection for the trooper.
yes, we do.
In the May 14th letter that was issued well after the fact, and that to me, I look at 12.7 and it notes that permanent employment not be dismissed or removed or subjected to any discipline until he's been given that Loudermill letter. And that letter gave him a 7-day window. That window had closed before the suspension was rescinded, right?
Yes.
Okay, and then there was not a subsequent Loudermill letter issued that gave him the right to present all evidence that he wanted, which gives his due process protection. It also gives the colonel, his command staff, the opportunity to consider the trooper's response in issuing any discipline, right?
Yes, he did not submit any response to the May 14th letter.
There was not with the May 14th letter, his deadline had passed. He had no right under that letter, I read it, to submit anything. He was given
So-
7 days and that had passed.
So May 14th was his Loudermill letter informing him of the intended discipline.
Yeah.
After he received that, now he has the opportunity to respond. He has a 7-day window to respond
But he had already been disciplined.
prematurely.
Right. So when y'all rescinded the discipline, was he given a new Loudermill letter that resurrected his due process rights to give him the opportunity to put in front of the command staff the facts he wanted them to consider and to give the command staff the opportunity to consider his facts? I think the record as I have it shows there was no such subsequent Loudermill letter issued to trigger his due process right.
No, there was not a second Loudermill letter issued. But on June 24th, 2025, Ms. Kraft did respond to our department acknowledging So on June 24th, 2025, Ms. Kraft did send a response to the department saying that she received on behalf of Lieutenant Jefferson's letter on May 19th. And she acknowledged it was a pre-deprivation letter. So we did receive a response although outside the window of the 7 days, we did receive a response it has been included in his appeal. And I would like to list this as Exhibit 12.
If I may, Mr. DeBose, I did respond to the original May 15th, 2025. Read it for May 14th. I responded to that on May 20th. That's your Exhibit F. When we got the 2 letters in June saying, oops, we made a mistake. There was June 20th and June 24th. That wasn't another Loudermill notice. That was just, we're going to put his time back. I again responded saying, look, you can do that, but that doesn't correct the procedural defects that we noted in our response of May 20th.
Thank you.
Yes, sir.
Thank you. Back.
Can I point one more thing out too? In the 2 letters, which are in my package, Exhibit H, the letter June 20th and June 24th. These are not new Loudermill notices, and in fact, that's acknowledged in the June 24th, 2025 letter from Colonel Hodges to Lieutenant Jefferson, where he acknowledges at the time my client served the suspension, he had not received a pre-deprivation letter before serving the suspension, therefore the suspension was premature. And then he goes on again, as he did in the June 20th letter, to say to rectify that error, we've merely reinstated your time as K time. It is not a Loudermill notice, a new Loudermill notice at that time. Thank you.
Further discussion?
I would like to make one point, just to clarify. When legal, i.e. me, sent a letter to sent an email to Captain Jonas requesting dates for suspension. That is a normal procedure that is done in the agency. Just to be precautionary, if there may be vacation or classes scheduled, we wouldn't want to put him on suspension dates where stuff would have to be rescheduled or just rescheduled, basically.
Yes. I'm not maybe looking at my phone, but I'm looking at something pertaining to this matter. And I know we're not under the Bill of Rights for police and firemen that are codified in by statutes, but there is an AG opinion back in 2007 that discusses when an investigation begins. I'm going to let you comment on whether you believe this is applicable to our case. There's under this AG opinion 07-0073 dated July 12, 2007. Is under police officer and fire employee statutory bill of rights. An investigation begins when an authorized person begins to make inquiry or collect evidence concerning a situation with an officer where the end result is with the view to possible disciplinary action.
So I know the rules specifically state, the police commission rules specifically state that the commission views the police bill of rights as unconstitutional. However,
As applied to troopers.
yeah, as applied to troopers. But I agree with that statement when evidence is starting to get gathered. So between the window of February 6th to either February 12th or 13th, evidence was being gathered. The request for the police report was made. The police report wasn't received till February 12th.
Inquiries were made and evidence was being collected with a view towards possible disciplinary action.
Yes.
Any further? I'll entertain a motion for session. So moved. So moved. Second. Roll call vote.
Ross Bourgeois,
Yes.
Mark Holmes,
Yes.
Michael Dumas,
Yes.
Stephen Guidry.
Yes.
Jonathan Kern. Jim Kowalski. Monty Montalago.
Passes. Members of the public are asked to exit the atrium executive session. Please bring your belongings with you. This time I'll entertain a motion to come out of executive session.
Second.
So moving to second, all in favor?
Aye.
Any opposed? Passes. And at this time, I'll accept a motion regarding the pending matter.
I would make a motion and start with recognizing Lieutenant Jefferson's property rights and his employment. And the Loudermill notice being the linchpin of those due process rights. I find based on the record before, in my opinion, the Loudermill notice requirements were not met. He was not provided a Loudermill notice prior to the actual imposition of the disciplinary action and given an opportunity to respond. Not only did it deprive Lieutenant Jefferson of his opportunity to avail himself of his full due process rights, but it also deprived the appointing authority from the opportunity to consider all available facts. So based on that, I would make a motion that summary disposition be granted on that basis and that Lieutenant Jefferson's be reinstated, all leave, pay, benefits, and emoluments of office.
So moved. Do we have a second?
Second.
All in favor?
Aye.
Any opposed? Guys have it. The motion passes. I'll entertain a second motion as to attorney fees.
Mr. Chairman, I move to award attorney fees to the appellant's counsel in the amount of $1,500.
So moved. A second?
Second.
Moved in second. All in favor?
Aye.
Any opposed? Guys have it. Okay.
Thank you.
Thank you. Thank you.
At this time, we'll move to item 4, consideration of a motion to adopt a revised pay schedule for the State Police Commission's 4 classified administrative positions effective February 12th, 2026.
Mr. Chairman,
Yes.
this agenda item is proposed to update the commission's unclassified pay schedule for its administrative positions. In 2019, the commission adopted a quartile-based structure to keep our positions comparable to the civil service administrative schedule, built out for budgeting of annual performance increases. And the commission last updated the structure in 2023 after civil service maximums increase. And since that time, there have been additional adjustments, with the most recent being effective February 2nd, 2026, and approved by the governor. So to maintain alignment with those comparable civil service ranges, it's recommended that the commission adopt the revised schedule presented in your materials behind tab 4. The changes only affect headroom at the top of the ranges and do not have a fiscal impact on the commission's budget.
Do I have a motion? So moved.
Second.
Second, all in favor?
Aye.
Any opposed? Motion passes. Move to item 7. For the record.
Mr. Chairman, behind the Director's Report tab in your binders, you'll see the commission's monthly expenditures, which are provided for your review. Any questions about the expenditures of the commission? Next, I'll announce the announcement that an application has been posted for the upcoming May 2026 promotional exam. This is a mandatory retest year. I really want to thank our test administrator and the state police subject matter experts for their efforts to conduct a comprehensive review of all test materials this cycle. It's an enormous undertaking, but they are engaged and excited for the challenge. Since posting that, the applications have been flooding in. Have a good test cycle this May. Additionally, we're gearing up for upcoming legislative session. Our first budget meeting is scheduled with House Committee on Appropriations on Tuesday, March 3rd at 9 a.m. and all are welcome to attend. I'll be there. And then I have to announce that our next meeting is scheduled for March 12th. We will not have an appeal hearing. Therefore, we're scheduled to begin at 10 a.m. That concludes my director's.
Thank you. For the record, are there any submissions to address the committee?
Chairman, there were not.
I'll entertain a motion to adjourn.
So moved.
Second. All in favor? Aye. Thank you.
Have a safe Mardi Gras.